Hello and welcome back. If you're new, it's nice to meet you. On this channel, I mostly read legal documents out loud, and I try to save the commentary for the professionals. Today's document is part 2 in a series called Silence of the Lamb, regarding a gag order proposed by the prosecution. The file is called Defendant Karen Reed's Opposition to the Commonwealth's motion to prohibit prejudicial, extrajudicial statements of counsel in compliance with Massachusetts Rules of Professional Conduct 3.6a. It's 19 pages long, and it's pretty well organized. It also includes an affidavit from David Yannetti, which I will read because oftentimes the accompanying affidavit is a great summary of the legal argument. This one is 7 pages long, if that's any indication of what we're about to cover. The documents are dated July 14th, 2023. Just a heads up, for efficiency's sake, we'll hop over some of the case citations and footnotes just to keep things running smoothly. Are you ready? Let's get to it. Now comes the defendant, Karen Reed, and respectfully moves this honorable court to deny the Commonwealth's motion to prohibit prejudicial, extrajudicial statements of counsel in compliance with Massachusetts Rules of Professional Conduct 3.6a. As grounds therefore, Ms. Reed states that her counsel are allowed to make statements that reasonable attorneys would believe are required to protect her from undue prejudice resulting from publicity not initiated by her pursuant to the Massachusetts Rules of Professional Conduct 3.6c. Further, the government's proposed order would impinge upon defense counsel's First Amendment rights to a degree that is not outweighed by any substantial governmental interest unrelated to the suppression of their statements. Factual background. Upon Ms. Reed's first arrest in this matter, Boston Police Superintendent-in-Chief Gregory Long released the following statement. The Boston Police Department continues to grieve over the tragic loss of our brother, Police Officer John O'Keefe. John was a kind person, dedicated to his family, and will be greatly missed by his coworkers and anyone who had the privilege of meeting him. Today, the Massachusetts State Police and the Norfolk County District Attorney's Office arrested the person responsible for John's death, emphasis added. At the very outset of this matter, Superintendent-in-Chief Long, an agent of the Commonwealth, publicly released a statement intended to prejudice Ms. Reed's defense, announcing her guilt before a shred of evidence had been presented or a trial had been conducted. No presumption of innocence was afforded to her by the government, and yet the Commonwealth issued a public statement to community characterizing her as a killer. Superintendent-in-Chief Long's statement was widely disseminated by media outlets. That inherently prejudicial statement was released on both the official Facebook account and official Twitter account of the Boston Police Department, in addition to being posted to the official website of the Boston Police Department. Following a press release from the Norfolk County District Attorney's Office indicating that Ms. Reed would be arraigned in Stoughton District Court on February 2, 2022, and following her arraignment, Superintendent-in-Chief Long took the opportunity to speak with members of the press in full uniform, lamenting the loss of an officer, especially under circumstances like this, referring to Karen Reed. As of the date of this filing, a video posted by CBS Boston on YouTube, which includes Superintendent-in-Chief Long's statement, has 83,000 views. Following Ms. Reed's indictment by a grand jury in Norfolk County, the Norfolk County District Attorney's Office issued yet another press release naming Karen Reed as the sole suspect in the death of John O'Keefe. More recently, following revelations that Jennifer McCabe ran a Google search for "How Long to Die in Cold" at 2:27 a.m. on January 29, 2022, hours before Officer John O'Keefe's hypothermic body was discovered in the snow on her brother-in-law Brian Albert's 34 Fairview Road residence, Both Ms. McCabe's attorney, Kevin Reddington, and Canton Police Chief Helena Rafferty commented publicly. On April 20th, 2023, Chief Rafferty posted the following message on the Canton Police Department's Facebook and Twitter pages, in which she publicly contended that facts presented by the defense were sensational accounts and that Ms. Reed's defense attorneys were unconstrained. Okay, y'all, I'm going to try to read this, but as you can see, it's teeny tiny and it's pretty poor quality. So let's hope it goes well. Patience. If I have learned nothing else in my 34 years as a police officer, it is the importance of exhibiting patience and waiting until I have as much information as possible before coming to conclusions. Members of the Canton Police Department have read and watched the same sensational accounts as our townsfolk in the last few days. Unlike defense attorneys, prosecutors, and police are ethically constrained to what can be said outside the courtroom, particularly in criminal trials. More than a few members of the Canton community have asked me my thoughts about the recent publicity surrounding the death of John O'Keefe and the state police investigation that ensued. My best advice is to wait until the prosecution has been able to give their response to the Norfolk Superior Court judge sitting on the case. This will occur May 3rd. The matter is in the courts now, in front of an impartial judge. The justice system works slowly because both sides are given the opportunity to have a full and fair hearing before an impartial and neutral judge or a jury of the defendant's peers. For our part, the focus of the men and women of Canton Police Department is the well-being and protection of the two children that John was raising. I submit that is where our focus belongs. Ben Franklin once said, "Patience is a conquering virtue." Therefore, I am satisfied to be patient as the judge is presented with all the facts. Helena Rafferty, Chief of Police, April 20th, 2023. Attorney Kevin Reddington, meanwhile, spoke with members of the press on April 24th, 2023. In his statement to the Boston Herald, Attorney Reddington stated, in part, "My client, Jennifer McCabe, has been vilified in pleadings. The defense attorneys are spinning it. It's going nowhere. The whole scenario is baseless." He further stated, with no evidence or context regarding what may or may not have been asked, that Ms. McCabe has taken and passed a polygraph, something that he is well aware, as a prominent defense attorney in the Commonwealth, is inadmissible in Massachusetts courts, but that may nevertheless be a compelling narrative to the members of the public. David Traub, a spokesperson for the Norfolk County District's Attorney Office, also publicly spoke to members of the press regarding the critical McCabe Google search data. Mr. Traub made several statements regarding Ms. McCabe's Google search, including the following. Quote, "While prosecutors are ethically constrained in the statements that can be made outside the courtroom, the Norfolk District Attorney's Office is in receipt of the motion filed last week, and it is our expectation to have a detailed response to the court May 3rd that refutes the assertions in that motion." End quote. He then went on to state, quote, "It has not yet been determined that the defense has interpreted the raw data correctly. The Norfolk District Attorney's Office has asked the defense repeatedly," I'll scroll up here, "during the pendency of this matter to provide any actually exculpatory evidence to support their claims." End quote. In other words, despite the apparent ethical constraints Mr. Traub claimed to cite, he nevertheless directly contacted the press to suggest, one, that the defense team's interpretation of the Google data was not correct, and two, that the defense team should provide any actually exculpatory, quote-unquote, evidence to the Office of the District Attorney, a request representing a total inversion of the burden of proof required in criminal cases, a burden that underpins the very foundation of the United States justice system. On the date of May 3rd, 2023, hearing the president of the State Police Association of Massachusetts, SPAM, flanked by other members of SPAM, publicly vouched for the credibility of the prosecution's lead investigator, stating on the courthouse steps that he came out to throw his support behind Michael Proctor and the investigation. Boy, I bet he's eating his words now. This case is actively going on. Our homicide detectives here in Massachusetts are arguably the best in the country. Our solve rate is indicative of that. The association supports our members across the Commonwealth, and the facts of this case will speak for itself. In addition, an attorney for Brian Albert stated in open court and in filings in opposition to defendant's Rule 17 motion regarding Canton Animal Control and Canton Town Clerk records that Mr. Albert's dog Chloe had no history of attacking human beings. Instead, Mr. Albert's counsel suggested that Chloe was rehomed following an incident between two dogs. The defense is asking the reader to conclude that the dog in question has a history of attacking human beings, and that it was sent away because it was violent towards people. As with other defense assertions, this is not true. Having now received and reviewed the records from Canton Animal Control and the Canton Town Clerk, all parties are now aware that Mr. Albert's counsel's statement was false, and the assertion by the defense is true. Brian Albert's canine German Shepherd Chloe attacked not one, but two separate human beings, both of whom were taken to the hospital as a result of the dog's attack. One individual was bitten on the arms, neck, and leg. The other was bitten on the left hand. Finally, and perhaps most egregiously, on June 10, 2023, immediately after filing the instant motion requesting that the judge gag the defense team and prevent them from sharing details about the case outside the courtroom, the spokesperson for the Norfolk County District Attorney's Office told WCVB Boston, the news station where Brian Albert's attorney works as a legal analyst, that a newly available report prepared by the State Police Collision Analysis and Reconstruction Section, Trooper Joseph Paul, perhaps, establishes that Ms. Reed operated her motor vehicle in reverse for a period of time before striking the victim. The title of the article, published by WCVB, reads, Karen Reed Murder Case. Prosecution says they have new electronic vehicle data. Also asks judge to rein in defense's comments. The hypocrisy is staggering. In the wake of the deluge of negative and prejudicial media statements from the government, Ms. Reed suffered unyieldingly. She lost her job, her teaching position was taken away, friends abandoned her. Karen Reed's reputation was destroyed. She was a community pariah, and that was exactly what was intended by the individuals and agencies behind those statements. From the outset, as this court is likely aware, the Commonwealth had no objection to the extrajudicial statements of police officers, police chiefs, representatives of the DA's office, counsel for witnesses and suspects, or any other individual or organization. That is because those statements fit neatly into its own narrative of the case and serve to prejudice Karen Reed within the community. Now that the public has begun to ask serious questions about the validity of this prosecution, criticize the government's handling of this case, and question whether, in fact, Karen Reed is actually responsible for John's death, as stated so boldly by the superintendent-in-chief. Instead of answer these constituents' inquiries, the Commonwealth has taken the desperate position that it would rather muzzle the defense. Trials and hearings are public proceedings. The public has a right to be informed of how its representatives are conducting themselves, and the defense and others have a right to be critical of the exercise of the Commonwealth's power. While the Commonwealth now seeks to try its case in the dark by seeking an extraordinary order by this court, gagging Ms. Reed's entire defense team, the Constitution and basic notions of due process and free speech mandate otherwise. As is oft recited, sunlight is the best disinfectant. The media has begun to take an unprecedented interest in this case. If the media has questions, We, all parties, should be willing and able to answer those questions. Should Mr. Lawley or any of his colleagues take issue with anything that has been said to the media, they have every right to correct the record as they see fit. But gagging the defense because the Commonwealth is uncomfortable with the public interest in this case is not only unnecessary, it would be improper. The Commonwealth now seeks a gag order that will prohibit the defense team from being able to respond to media inquiries about the state of the case and to respond to previous prejudicial statements by the government, such as those noted above. Moreover, the Commonwealth has specifically requested that any witnesses and their counsel, including the third parties actually responsible for O'Keefe's death, including Jennifer McCabe and Brian Albert, be allowed to speak in public about this case with impunity, tying the hands of Ms. Reed's counsel such that they would be barred from rebutting false claims or rebutting false claims made by those parties would be a gross violation of her constitutional rights. A claim by the Commonwealth that any extrajudicial statement might affect a potential jury pool is hypocritical. The Commonwealth took an early opportunity to try and convict Ms. Reed in the court of public opinion. It cannot now cry foul when the defense responds to that prejudicial and false narrative to the very same public that the Commonwealth attempted to influence in the first place. Argument, Section 1. Ms. Reed's defense counsel have the right and the duty to respond to prejudicial publicity in a manner that is required to protect Ms. Reed from the unduly prejudicial effect of that publicity under Massachusetts Rules of Professional Conduct and the First Amendment to the United States Constitution. Massachusetts Rules of Professional Conduct 3.6c, provides the following. Notwithstanding paragraph A, a lawyer may make a statement that a reasonable lawyer would believe is required to protect a client from the substantial undue prejudicial effect of recent publicity not initiated by the lawyer or the lawyer's client. A statement made pursuant to this paragraph shall be limited to such information as is necessary to mitigate the recent adverse publicity. Also, the lawyer should represent a client zealously within the bounds of law. In its motion, the Commonwealth cites a Supreme Court case, Gentile versus the State Bar of Nevada, several times. Every time the Commonwealth cites this case, however, it relies on a section of Chief Justice Rehnquist's opinion, which concurred in part and dissented in part. The Commonwealth, curiously, completely ignores Justice Kennedy's majority and controlling opinion in its motion. The Commonwealth also fails to point out, moreover, that it is repeatedly citing a concurring opinion that is not binding precedent. Unlike the Hernandez case cited by the Commonwealth, which involves a motion to prohibit prejudicial extrajudicial statements filed by defense counsel in response to repeated leaks by the Commonwealth, Gentile provides important guardrails for permissible communications by defense counsel in analyzing a precursor to the ABA Model Rule of Professional Conduct 3.6. Mr. Gentile, a criminal defense attorney in Las Vegas, was disciplined by the Southern Nevada Disciplinary Board of the State Bar for a press conference that he held following the indictment of his client. Mr. Gentile's client was accused of stealing from deposit boxes at Western Vault. Saliently, Mr. Gentile told members of the press that his client was a scapegoat and noted that the state had not been honest enough to indict the people who did it, the police department, crooked cops. The deputy police chief involved in the investigation had previously announced that 2 detectives with access to the deposit boxes had been cleared as possible suspects. Local media reported that those 2 suspects had been cleared by police investigators after passing lie detector tests. In addition, one of the alleged victims of this theft and a witness at trial was also reported to have taken and passed a lie detector test. During his press conference, Mr. Gentile noted that some would-be trial witnesses and alleged victims had quote-unquote drug backgrounds, stating, quote, "I can't name which of the people have the drug backgrounds. I'm sure you guys can find that by doing just a little bit of investigative work," unquote. A member of the press questioned Mr. Gentile regarding alleged FBI involvement in the case. Question from the floor. I have seen reports that the FBI seem to think along the lines that you do. Mr. Gentile. Well, I couldn't agree with them more. Question from the floor. Do you know anything about it? Mr. Gentile. Yes, I do. But again, Dan, I'm not in the position to discuss that now. Following the acquittal of his client, Mr. Gentile was disciplined by the Southern Nevada Disciplinary Board of the State Bar for having violated Nevada Supreme Court Rule 177, a rule governing pretrial publicity almost identical to ABA Model Rule of Professional Conduct 3.6 during this press conference. In reversing this action by the State Bar, the Supreme Court of the United States held that Nevada's application of Rule 177 violated the First Amendment, and that nothing Mr. Gentile said created any real threat of prejudice either to his client's right to a fair trial or to the state's interest in the enforcement of its criminal laws. Justice Kennedy's majority opinion noted that there is no question that speech critical of the exercise of the state's power lies at the very center of the First Amendment. It would be difficult to single out any aspect of government of higher concern and importance to the people than the manner in which criminal trials are conducted. Public vigilance serves us well, for the knowledge that every criminal trial is subject to contemporaneous review in the form of public opinion is an effective restraint on possible abuse of judicial power. Without publicity, all other checks are insufficient. In comparison of publicity, all other checks are of small amount, emphasis added. And that comes to us from a case called Oliver from 1948. Justice Kennedy further noted that public awareness and criticism have an even greater importance where, as here, they concern allegations of police corruption. The Supreme Court noted that in holding a press conference, Mr. Gentile did not seek to materially prejudice it's so hard to see, an adjudicative proceeding. Instead, Mr. Gentile sought to stop a wave of publicity he perceived as prejudicing potential jurors against his client and injuring his client's reputation in the community. Mr. Gentile had acted in part, as the court noted, because the investigation had taken a serious toll on his client. His client was, quote, not a man in good health, unquote. Further, Mr. Gentile had lost a ground lease on a property of his prior to indictment, based purely on suspicion of wrongdoing. The similarities between the facts in Gentile and Ms. Reed's case are uncanny. In Gentile, the defense accused the government of scapegoating his client, when in fact the real culprits were police. The media were reporting alleged FBI involvement, which Mr. Gentile carefully commented on. A number of witnesses claimed to have taken polygraph tests. Mr. Gentile's client suffered difficulties with his health and financial loss as a result of his suspicion of wrongdoing. Finally, Mr. Gentile spoke directly with members of the press to try to counter a wave of publicity he perceived as prejudicing potential jurors against his client and injuring his client's reputation in the community. All of those same facts exist in Ms. Reed's case, and the purpose of Ms. Reed's defense counsel's statements to the press serve an identical purpose: to attempt to counter a wave of prejudicial statements against Ms. Reed, as is allowed under the Massachusetts Rules of Professional Conduct 3.6c. Justice Kennedy's majority opinion states that an attorney's duties do not begin inside the courtroom door. He or she cannot ignore the practical implications of a legal proceeding for a client, An attorney may take reasonable steps to defend a client's reputation and reduce the adverse consequences of indictment, especially in the face of a prosecution deemed unjust or commenced with improper motives. A defense attorney may pursue lawful strategies to obtain dismissal of an indictment or reduction of charges, including an attempt to demonstrate in the court of public opinion that the client does not deserve to be tried. The court found that since the potential jury pool, i.e., the population in Clark County, Nevada, consisted of 600,000 persons, and since Mr. Gentile's statements were made at a time when he knew a jury would not be impaneled for at least 6 months, there was no likelihood of prejudice based on his statements to the press. Similarly, here, no trial date in this matter has been set, and the population of Norfolk County as of 2022 was roughly 725,531. Critically, the Gentile court noted that the respondent and its amici did not present a single case where statements of a defense attorney had managed to prejudice the prosecution of the state's case. Quote, the various Bar Association and Advisory Commission reports which resulted in promulgation of ABA Model Rule of Professional Conduct 3.6 from 1981, and other regulations of attorney speech and sources they cite, present no convincing case for restrictions upon the speech of defense attorneys. Let's see, that comes to us from 1984. Summarizing studies and concluding there is no empirical or anecdotal evidence of a need for restrictions on defense publicity. It says also see a case referred to as Dreschel. Data showing the heavy reliance of journalists on law enforcement sources and prosecutors confirms the appropriateness of focusing attention on those sources when attempting to control pretrial publicity. The Gentile court further notes that only the occasional case presents a danger of prejudice from pretrial publicity. Empirical research suggests that in a few instances when jurors have been exposed to extensive and prejudicial publicity, they are able to disregard it and base their verdict upon the evidence presented in court. The court paid special attention to the fact that speech by a defense attorney should be afforded the traditional First Amendment protections, and less justification exists for censoring speech of a defense attorney as compared to police or prosecutors. Supreme Court cases recognize that disciplinary rules governing the legal profession cannot punish activity protected by the First Amendment, and that First Amendment protection survives even when the attorney violates a disciplinary rule he swore to obey when admitted to the practice of law. The Commonwealth's characterization of statements made by defense counsel, specifically those attributed to Alan Jackson, is misleading, lacks context, and is outright deceptive. For example, on page 7 of its memorandum, the Commonwealth states, furthermore, during the May 3, 2023 hearing, defense counsel first reported in open court during a live television broadcast that federal authorities have now gotten involved in the circumstances surrounding this case and have impaneled a federal grand jury, to investigate some of these circumstances. Critically, the Commonwealth, in an effort to cast Attorney Jackson's statements in the most nefarious light possible, omitted the prefatory clause preceding the statement. What Attorney Jackson said prior to the statement was, "It's been reported that." At the time the statement was made, it had indeed been publicly reported that a federal grand jury had been impaneled. There is a marked difference between stating that something has been reported and revealing something that was previously unknown to anyone. This statement was not the defense revealing publicly that a federal grand jury had been impaneled, something about which the defense team would have no knowledge. Instead, as Attorney Jackson stated, this was Ms. Reed's counsel reiterating what had already been publicly reported. Most importantly, That was not an extrajudicial statement, nor did Attorney Jackson or anyone on the defense team make an extrajudicial statement about the issue. Attorney Jackson stated that in open court, as part of a legal argument to this court, it is disingenuous for the Commonwealth to muddy the waters when seeking to gag the defense by citing an appropriate argument made in a courtroom in compliance with the defendant's Sixth Amendment rights. I'm glad they're calling them out on that. Additionally, the Commonwealth suggests that defense counsel directly encouraged media outlets to continue to contact witnesses and ask them inflammatory questions in step with the defendant's theory of the case. This is an absurd characterization of what Attorney Jackson actually said during the quote-unquote press conference the Commonwealth references. What Attorney Jackson stated upon the defense team being encircled by members of the press on the courthouse steps was, "Don't you want to ask some questions? I know you do. Let me give some examples. Here's some questions you might want to think about asking. Why did Jennifer McCabe's Google search, 'How long to die in cold' at 2:27 in the morning, 3.5 hours before she would have any reason to believe that John O'Keefe was dying in the cold in front of John O'Keefe's house?" I don't know why it says that instead of in front of Brian Albert's house, but whatever. Why don't you ask the question, why did she scrub her phone? Why did she take the time to scrub her phone before she turned it into the police? Why did she delete any and all reference to her communications with Brian Albert on the 29th, on the 28th? Here's another question. Why did Brian Albert get rid of the dog? Far from being a call to action to harass witnesses, these suggestions of possible investigation to the press by Attorney Jackson are reminiscent of Mr. Gentile's suggestion to members of the press that they could find relevant information by doing just a little bit of investigative work. Let's see. I lost my place. Let's see. Okay, here we go. I'm so sorry. Similarly, Attorney Jackson's comments in court, which are not extrajudicial in nature, regarding the supposed existence of a federal grand jury, are reminiscent of Mr. Gentile's statements that he agreed with the FBI's conclusion regarding that case. In contrast with Mr. Gentile's statements, which confirmed he knew about an ongoing FBI investigation, Attorney Jackson merely reiterated what had been publicly reported. Further, in contrast with Mr. Gentile's statements regarding the FBI's investigation, Attorney Jackson was silent on this issue outside the courtroom. In addition, the Commonwealth, at several points in its memorandum, fails to differentiate which members of Ms. Reed's team have made which statements, despite naming all four attorneys, Attorney David Yannetti, Attorney Ian Henchy, Attorney Alan Jackson, and Attorney Elizabeth Little, in the first sentence of its memorandum. Neither Attorney Henchy nor Attorney Little have made any public statements regarding this case, yet the Commonwealth seeks to impugn the character of and suggest misconduct by all four attorneys through misleading characterizations of some of Attorney Jackson's statements. Finally, the Commonwealth states that the defense team has engaged in a trial by media strategy while ignoring that it is the Commonwealth that involved the media from the very outset of this case. The Norfolk County District Attorney's Office began its press releases stating when and where Ms. Reed's initial district court arraignment would take place, thereby encouraging members of the press to attend. Further, as noted above, Superintendent-in-Chief Long prejudiced this case and sought to taint the jury pool as soon as Ms. Reed was charged for the crime by stating, "Today, the Massachusetts State Police and the Norfolk County District Attorney's Office arrested the person responsible for John's death." Defense counsel has every right to rebut such an extraordinarily prejudicial statement by pointing out that Ms. Reed was not responsible for Officer O'Keefe's death pursuant to the provisions of Massachusetts Rules of Professional Conduct 3.6c. Similarly, defense counsel has every right to rebut the Commonwealth's repeated assertions through its spokesperson, David Traub, that it had misinterpreted Jennifer McCabe's Google search data. The defense also has the right to rebut Mr. Albert's counsel's factually false assertions that his dog had no history of violence towards people, as well as Attorney Reddington's statements that the defense counsel's theory of the case is baseless and going nowhere. Furthermore, even after the Commonwealth's filing of this motion, the spokesperson from the Norfolk County District Attorney's Office has released yet another statement to the press, falsely suggesting that electronic vehicle data establishes Ms. Reed reversed into the victim with her vehicle at a high rate of speed, a suggestion that Ms. Reed and her counsel have a constitutional right to rebut. Beyond the right to rebut all these statements, defense counsel asserts that the defense team has a duty to rebut these allegations in order to zealously represent Ms. Reed and in accordance with Massachusetts Rules of Professional Conduct 1.3. The defense did not initiate a trial by media strategy in this matter. The Commonwealth did. The Commonwealth did not protest or complain when the media narrative appeared to be consistent with their theory. It was only when the public took a hard and critical look at the Commonwealth's theory of this case, based upon publicly filed documents, and started to question that theory, that the Commonwealth filed this motion to gag the parties. Given what the Commonwealth has already done to poison the well of public opinion, the defense has the right, and indeed the duty, to rebut prejudicial statements made by the Commonwealth, the media, and counsel for the parties involved in Officer O'Keefe's death under both Massachusetts Rules of Professional Conduct 3.6c and the First Amendment. Number 2. The Commonwealth's proposed gag order, if allowed, would be an impermissible viewpoint-based prior restraint on speech in violation of the First Amendment and Article 16 of the Massachusetts Declaration of Rights. Prior restraints on speech are presumptively unconstitutional. Viewpoint or content-based restrictions on speech are similarly unconstitutional. As the Supreme Court has noted, viewpoint discrimination is an egregious form of content discrimination. The government must abstain from regulating speech when the specific motivating ideology or the opinion or perspective of the speaker is the rationale for the restriction. Despite the Commonwealth's language in its proposed order that it, quote, seeks only mutual attorney compliance with the Massachusetts Rules of Professional Conduct, unquote, the proposed gag order is a viewpoint-based because it clearly is pointedly designed to apply solely to Ms. Reed's defense team. The Commonwealth has seemingly made no effort to prevent prejudicial, extrajudicial statements prejudicing the jury pool against Ms. Reed, and is seemingly unconcerned with the statements made by agents of the Commonwealth, e.g. Superintendent-in-Chief Long, and the Norfolk County District Attorney's Office spokesperson, as there is no mention of any of these statements in the Commonwealth's memorandum. Only when media coverage began to question the narrative presented by the Commonwealth did it suddenly become concerned with, quote-unquote, mutual attorney compliance with the rules of professional conduct. In other words, the Commonwealth was more than happy to have Ms. Reed's trial occur in the court of public opinion, right up until the moment when the press began asking questions about the propriety of the Commonwealth's investigation and, by extension, its case against Ms. Reed. It's clear from the language of the Commonwealth's memorandum that this attempt to seek a gag order against the defense is motivated by its frustration that reporting on this case has begun to include information favorable to the defense. This order seeks to prohibit the defense from rebutting the Commonwealth's narrative of the case, which has been pervasive since February 1st, 2022. Quote, A trial court's order that prohibits or limits the speech of lawyers or parties before the court, a so-called gag order, is a prior restraint, unquote. While it is true that, quote, under some circumstances, First Amendment rights must give way during a criminal proceeding in order to preserve a fair trial, unquote, a court must first determine whether an order restricting speech meets the requisite legal standard for any such restriction. Prior restraints and viewpoint or content-based restrictions can only be justified if they satisfy the strict scrutiny test. That is, they are necessitated by a compelling governmental interest and are narrowly tailored to serve that interest. The Commonwealth's proposed gag order is not justified by a compelling governmental interest. While the Commonwealth cites a number of cases, including those which mention that a trial judge has a duty to minimize pretrial publicity to safeguard the due process rights of the accused, it is worth noting that the Commonwealth cannot point to a single case where the statements by defense counsel prejudiced the government's case. Instead, the Commonwealth cites cases such as the non-binding and off-point slip opinion from Commonwealth v. Hernandez, which was in response to a renewed motion from defense counsel regarding pretrial publicity. At issue in that case was an agent of the Commonwealth, specifically the Massachusetts State Police, repeatedly leaking details of their investigation to the press. The Commonwealth went so far as to apparently alert Sports Illustrated that a professional football player would be served with a grand jury subpoena following a New England Patriots football game, such that a Sports Illustrated photographer was waiting to photograph the moment the Massachusetts State Police served that player following the game. Oh, that's awful. The suggestion that the Commonwealth's proposed order in this case somehow seeks or serves to preserve Ms. Reed's right to a fair trial is absurd on its face. The Commonwealth seems to be arguing that it knows better than Ms. Reed's legal team how to best preserve her right to a fair trial. The Commonwealth's proposed gag order is clearly in response to media coverage favorable to the defense. It would accordingly apply primarily to the defense, despite the Commonwealth's next page, careful language, and therefore cannot be said to serve the compelling governmental interest in seeking to preserve Ms. Reed's right to a fair trial. Even assuming for the sake of argument that there is a compelling governmental interest in it seeks to protect, the gag order is not narrowly tailored to achieve its supposed objective. By seeking to preclude the defense from disseminating by any means of public communication the substance of any evidence a party anticipates seeking to introduce at trial, the Commonwealth seeks to ensure that only its narrative, and not that of the defense, is disseminated in the press. By way of a concrete example, the Commonwealth failed to produce in discovery a report noting that Jennifer McCabe ran a Google search for how long to die in cold at 2:27 a.m. on January 29, 2022. This information was discovered by the defense after fighting for a full forensic extraction of Ms. McCabe's phone for an extended period of time. Had the Commonwealth's order been in effect at that time, the defense presumably would have been precluded from disseminating by any public communication that it had uncovered this information, lest the defense face quote-unquote admonition or disbarment, or the quote-unquote revoking pro hoc vice admission to the Massachusetts Bar of Ms. Reed's chosen attorneys. The Commonwealth's request that all attorneys in the case be precluded from releasing any photographs, reports, or documents that are not in public record is similarly overbroad. Massachusetts Rules of Criminal Procedure 14A6 authorizes the court to impose protective orders on materials obtained through discovery. It does not authorize the court to dictate how the defendant's own materials not obtained through discovery should be dealt with. A protective order prevents a party from disseminating only that information obtained through the use of the discovery process. Thus, a party may disseminate the identical information covered by the protective order as long as the information is gained through means independent of the court's process. Accordingly, under the terms of the Commonwealth's proposed order, the defense would be precluded from disseminating any photographs, reports, or documents the defense has generated, even assuming the Commonwealth sought to protect a compelling governmental interest for the sake of argument, then the order is not narrowly tailored to achieve that end. Accordingly, since the Commonwealth's proposed order is both a prior restraint on the defense team's speech and represents a viewpoint and content-based restriction that is not narrowly tailored to preserve a compelling governmental interest, the Commonwealth's motion must be denied. Conclusion. It is anathema that a defendant, no matter who she is at a substantial disadvantage compared to the juggernaut of the government in a criminal case. Sorry, if you're looking at the screen, you could tell it's like all smudged up. I wish that Lolly had done a better job of submitting clean copies. Okay, given this resulting imbalance of power, the criminal defendant should have some leeway in addressing the public and, at the very least, should not be more limited than the government. The Commonwealth, under the guise of seeking a mutual gag order, seeks to ensure that it will maintain narrative control in its case against Ms. Reed. The Commonwealth's proposed order would cut off defense counsel's ability to rebut prejudicial statements made by the Commonwealth, its agents, the media, and attorneys for interested third parties, and represents an impermissible prior restraint on speech. Further, the Commonwealth cannot point to any circumstances in which it would be prejudiced by any statement or statements made by the defense counsel to the media or public. That is because, as courts have long recognized, such circumstances simply do not reasonably exist. As pointedly stated by the United States Supreme Court, it would be difficult to single out any aspect of government of higher concern and importance to the people than the manner in which criminal trials are conducted. Public vigilance serves us well, for the knowledge that every criminal trial is subject to contemporaneous review in the form of public opinion is an effective restraint on possible abuse of judicial power. Without publicity, all other checks are insufficient. In comparison of publicity, all other checks are of small amount. Of course, defense counsel will continue to comply with the Massachusetts Rules of Professional Conduct and will continue to ensure compliance with SJC Rule 1.24. The order sought by the Commonwealth here, however, goes far beyond seeking to ensure compliance with those rules. Accordingly, Ms. Reed respectfully requests that this honorable court deny the Commonwealth's motion. Respectfully submitted, David Yannetti, and all of the other attorneys seem to have signed below as well. And again, the date on this is July 14th, 2023. Now let's take a look at the affidavit in support of what we just read. I, David R. Yannetti, do hereby depose and state that the following is true to the best of my knowledge, information, and belief. Number 1, I am an attorney licensed to practice in Massachusetts since December 20th, 1989. My office address is Yannetti Law Firm, 44 School Street, Suite 1000A, Boston, Mass. 02108. I represent Karen Reed, Ms. Reed, regarding the above captioned matter. Number 2, the factual background detailed in Ms. Reed's opposition is true and accurate to the best of my knowledge, information, and belief, and is incorporated here in full by reference. Number 3, I have represented Ms. Reed since January 29, 2022, the same day that John O'Keefe's body was found on the property of Brian Albert. From the beginning, I have carefully followed and reviewed statements made by the Commonwealth and its agents, as well as interested third parties with respect to Ms. Reed. Number 4. On February 1st, 2022, following Ms. Reed's first arrest, I became aware of a public statement made by Boston Police Superintendent-in-Chief Gregory Long that I determined would prejudice the fair adjudication of this matter. The statement had significant potential to taint a potential jury pool in Norfolk County. Number 5. Specifically, Superintendent-in-Chief Long's statement read as follows: The Boston Police Department continues to grieve over the tragic loss of our brother, Police Officer John O'Keefe. John was a kind person, dedicated to his family, and will be greatly missed by his coworkers and anyone who had the privilege of meeting him. Today, the Massachusetts State Police and the Norfolk County District Attorney's Office arrested the person responsible for John's death. Emphasis added. Number 6. This statement, which assumed and suggested Ms. Reed's guilt even before she had been arraigned in district court, was publicly disseminated through the Boston Police Department's official channels and was picked up and repeated by numerous media outlets, including NBC Boston, ABC News, and 7 News Boston. Number 7. Following Superintendent-in-Chief Long's statement, the Norfolk County District Attorney's Office issued a press release indicating when and where Ms. Reed's arraignment would take place. Number 8. Superintendent-in-Chief Long attended that arraignment, seizing the opportunity to speak with members of the media in full uniform after Ms. Reed's initial appearance. He stated in part that, quote, "To lose anybody, any member, especially under circumstances like this, it's tough." Number 9. A CBS Boston news clip discussing Ms. Reed's arraignment, which included the above-referenced quote from Superintendent-in-Chief Long, has over 83,000 views to date. From the outset, this case has received significant and overwhelming attention from members of the media. Number 10. The Norfolk County District Attorney's Office has issued many statements through the media and official channels within its office, a number of which I deemed similarly prejudicial to the fair adjudication of Ms. Reed's case. Number 11. In addition to press releases, David Traub, the spokesperson for the office, has spoken to the media regarding this matter on more than one occasion. Number 12. Following revelations that Ms. Jennifer McCabe ran a Google search for how long to die in cold at 2:27 a.m. on January 29, 2022, hours before Officer John O'Keefe's body was discovered outside of Brian Albert's 34 Fairview Road residence, Mr. Traub made the following statements to media outlets. A. While prosecutors are ethically constrained in the statements that can be made outside the courtroom, the Norfolk District Attorney's Office is in receipt of the motion filed last week, and it is our expectation to have a detailed response to the court May 3rd that refutes the assertions in that motion. And B. It has not yet been determined that the defense has interpreted the raw data correctly. The Norfolk District Attorney's Office has asked the defense repeatedly during the pendency of this matter to provide any actually exculpatory evidence to support their claims. Number 13. I thought the latter of these two statements to be extraordinary. Not only was it not true that the Norfolk County District Attorney's Office had asked the defense to provide any quote-unquote actually exculpatory evidence, but that statement represented a complete inversion of the burden of proof in a criminal trial. Number 14. Mr. Traub continued to make public statements on this issue, stating that the prosecution would be disproving the defense team's interpretation of the data. Number 15. Upon information and belief, the defense's interpretation of the data is completely accurate. The Norfolk County District Attorney's Office has not disproven anything. Even an outside expert hired by the Commonwealth was unable to say definitively that Ms. McCabe had not ran this Google search at 2:27 a.m. While a definitive reason as to why the timestamp is listing the time at 2:27:40 is unknown, the time is inconsistent with the timestamps associated with the same search. Emphasis added. Supplemental filing in support of memorandum in opposition to defendant's motion pursuant to Rule 17 of Criminal Procedure, directed to Brian Albert, Verizon, and AT&T on page 32. Number 16, Canton Police Chief Helena Rafferty, despite her department supposedly having abandoned the investigation into this case as a result of conflict of interest, given that John O'Keefe's body was found on the property of the brother of a Canton police officer on January 29, 2022, released a public statement stating that members of the public should wait until prosecution has been able to give their response to the Norfolk Superior Court judge sitting on the case, and that response would occur on May 3rd. Number 17. Jennifer McCabe's attorney also weighed in publicly on this issue. He stated to the Boston Herald, "My client, Jennifer McCabe, has been vilified in pleadings. They are spinning it. It's going nowhere. The whole scenario is baseless." He further noted that Ms. McCabe had taken and passed a polygraph examination, something I know to be inadmissible in court, but which may nevertheless represent a compelling narrative to the members of the public. Number 18. An attorney for Brian Albert has also attempted to refute publicly aspects of the defense theory. It is worth noting that Mr. Albert's attorney is a legal analyst at WCVB News. Number 19. In opposition to a Rule 17 motion filed by Ms. Reed, Mr. Albert's attorney suggested that Mr. Albert's dog Chloe had no history of attacking human beings. Instead, Mr. Albert's counsel suggested that Chloe was rehomed following an incident between two dogs. The defense is asking the reader to conclude that the dog in question has a history of attacking human beings and that it was sent away because it was violent towards people. As with other defense assertions, this is not true, unquote. Number 20. Having reviewed the records, the defense assertions were indeed true. Those records clearly demonstrate that Chloe, in fact, attacked two people, both of whom were taken to the hospital for medical treatment. Despite protestations to the contrary to the media, it was the assertion of Brian Albert's attorney that was untrue. Number 21. More recently, in its motion to prohibit extrajudicial statements, the Commonwealth stated that it has evidence that establishes that the defendant, while intoxicated in a snowstorm, operated her motor vehicle in reverse for a period of time before striking the victim at a high rate of speed. Number 22. In a statement to WCVB News, where Mr. Albert's attorney works as a legal analyst, Norfolk District Attorney's Office spokesman Mr. Traub stated that the information in the preceding paragraph was based on their reading of a newly available report prepared by the State Police Collision Analysis and Reconstruction Section of Reed's Vehicle Data. Number 23. That allegation was again picked up by a number of media outlets, including Boston Magazine, Boston 25 News, the Patriot Ledger, the Sun Chronicle, and more. Number 24. The Sun Chronicle stated in its article on this issue, quote, Boston television station WCVB Channel 5 reported the information came from a recent report of an analysis of the black box in Reed's SUV. Number 25. As has often been true in this case, this statement is not quite accurate and is at best misleading. Without further revealing any of the contents of the referenced report, Ms. Reed's Event Data Recorder, EDR, is what is traditionally referenced when referring to a vehicle's quote-unquote black box. It showed no events, i.e. no impacts or accidents. since there were no deployment or non-deployment events, i.e. accidents, recorded, the EDR, black box, would not show any of the information referenced by the Norfolk County District Attorney's Office in its filing. Number 26. Upon information and belief, had Miss Reed reversed her vehicle into anything at a high rate of speed, the event would have been recorded by her vehicle's EDR. Number 27. All of these statements against Ms. Reed have significantly prejudiced her ability to have a fair trial on this matter. Number 28. I am aware of my obligations under Massachusetts Rules of Professional Conduct 3.6. I am also aware that I am allowed to make similar public statements if I believe that they are required to protect my client from substantial prejudice under the Massachusetts Rules of Professional Conduct 3.6c. I am not aware of any case in which the government's case has been prejudiced by defense statements. Number 29. In my view, statements made by the defense team have been necessary to protect Ms. Reed from the substantially prejudicial statements made by the Commonwealth, its agents, members of the media, and attorneys for interested third parties in this case. Number 30. For these reasons, the defense respectfully requests that this honorable court denies the Commonwealth's motion. Signed under the pains and penalties of perjury this 14th day of July, 2023. Oh, y'all, I am literally shaking with anger right now. I cannot believe, well, I mean, I guess I can believe, but I can't believe that the Commonwealth flagrantly manipulated the law to try to obtain a gag order for the 88th millionth time. I cannot believe this case was allowed to move forward. I have the feeling that the defense would come back swinging. What do you think Judge Cannoni will say in her ruling? We'll take a look at her verdict in the next video. Thank you for listening. If you'd like me to continue making this type of comment, please comment below. I value your feedback so much. I hope that you'll subscribe so that you'll always be notified when the next one is released, because goodness knows with this case, there will always be a next one.